can look back on it and wonder if you did the right thing. And for some of you, it's very important. I think of Pete when I was thinking about this thing, and Pete's over there in Nevada now, and probably needs to develop a little business for the law firms. And we'll talk about that when we talk about this. I don't like the title of $1 Million Rainmaker. A friend of mine is a sales executive trainer, and he and I put this book together. It's sort of like a Ken Blanchard 1-minute management book. It's a long story with principles in the story. And we'll talk about that. But before we do, we want to take this 8.5 by 11 out, because I got this the other night at the end of the court meeting, and I thought, my God, that's exactly what we need to talk about. So we've got like 12 sections, so let's start with Pete. Pete, you do section 1, okay?
Okay.
So I want you to read that, and then we'll talk about it. And Cameron, why don't you do section 2?
Thank you.
I got to remember who's doing this. And Donald, why don't you do section 3? I'm sorry, I forgot your name.
Steve.
Dave.
Steve.
Pete.
Steve.
Say it again.
Steve. Steven.
Steve. Sorry, Steve.
Well, maybe it's not.
Yeah, maybe it's not.
Section 4.
Section 4.
I feel bad. Section 5. What's your first name again?
George.
George. Joel, man. Section 6 should be Rod. Perfect, Rod. Section 7 will be Claudia. Something you won't be familiar with, but that's okay. Section 8. Ready? Tell me your first name again.
Mike.
Mike. Sorry, guys, I should know everybody's first name, but that's what happens when you get this old. Front. Ken.
I can't read it. I'm
You
sorry.
can't read it.
No, I'm visually impaired, so I can't. All I see is a white piece of paper.
Can you have someone read it for you?
No,
Your wife read it to you?
no. Thank you. Sorry.
Okay, I'm not gonna give you that then.
Okay, thank you.
In the back. Ken. First name again?
Gabriel. What
Gabe.
happened to 9?
Did we not do 9?
I need it.
Again. Prepared myself. 9, we got Mike.
Okay.
10, we got Gabe. And 11, Rashid, of course. And I'll do 12. Civility and courtesy, professional courtesy and civility is what this series of materials is all about. Like each of you to read your section, and then we're just going to call on you to explain it to us. And I'll have comments, but before we do that, I want to make sure everybody's okay. Everybody got coffee? Everybody need to use the restroom? Okay. Go ahead and do that. We'll take 10 minutes to read this, and I'll call you back to order. gonna resume at 8:15, so keep your eye on the clock. Anybody still reading? Everybody finished? Let's just get going. Pete, take section 1. Remember, this is accepted terms of professional behavior for a successful functioning judicial system in the practice of law. This is the civility stuff.
So, section 1 has to do with scheduling and primarily the scheduling of meetings, hearings, and discovery. And it starts off with the preface that, utilizing civility and courtesy in scheduling is not to be equated with weakness and is not inconsistent with zealous representation of your client. A lawyer who manifests professional courtesy and civility makes reasonable efforts to schedule meetings, hearings, and discovery by agreement when possible, and considers the scheduling interests of opposing counsel. And of course, misunderstandings are avoided by sending formal notices. And when you're dealing with meetings, I think sending a follow-up formal confirmation of the date and time agreed works. Lawyers should not arbitrarily or unreasonably withhold consent to request accommodations. They should not engage in delay tactics in scheduling. They should try to verify the availability of key participants and witnesses before a meeting, hearing, or trial date is set, or if that's not feasible, immediately after notify the court and counsel if there are any problems. And likewise, notifies opposing counsel and the court if appropriate as early as possible when meetings, hearings, or depositions must be canceled or rescheduled.
Don't schedule when your opposing counsel's vacation or something.
Exactly.
I swear, when we were young lawyers, we used to call the CHP and find out when the officer was going to be unavailable. And then we try and set our cases. I feel so bad about that, but that seemed like something everybody was doing. And it was just a dumb thing. The CHP are the toughest in DUI cases. And they're very liberal on the telephone when you say, "Hi, I'm on this case." I presume that they assumed I was a DA, which we were not. But they say, "This guy got a vacation coming up, or training, or whatever."
Yeah.
We were trying to set up in those days. That's just rotten.
Yeah.
But we didn't know any better. It didn't help that much, because they usually figure out a way to get there. But you, the guys that do civil, I take it you have all the time need to schedule depositions and other meetings. And sometimes some people just won't do it. Same with continuances. People say, "No, I don't want to agree to that," even though there's good cause for it.
Well, I was just going to say, I remember not too far in the past, probably about 13, 14 months, opposing counsel on a case sent a deposition. We agreed on Riverside. It was one of my witnesses. And so me and my witness drove to Riverside for this deposition, and we're waiting, and we're waiting, and we're waiting. Nobody ever showed up. No call, no courtesy, no nothing. They had filed for bankruptcy the day before, which of course instituted an automatic stay, but we didn't receive notice of that either. And when we're calling, of course, not available, right? There's no answer. Just look, if you're gonna do that,
where they filed bankruptcy.
yeah, you're gonna do that. A courtesy call. How hard would that be to make? Have your assistant call.
What a concept.
Hey, save us the drive. But there was a contentious case.
Were you driving from Nevada at the time?
No, I was here in the desert. Because I had come in the day before to prep the witness. So.
Well, that's the kind of rotten stuff that happens. I said yesterday, might have sounded a little frivolous, but I honestly think criminal lawyers are easier to get along with and work with than civil lawyers. You don't have people curse you over the telephone because you asked for a continuance or whatever. And most people, once you know each other, you work in the same environment, get along pretty well. Somebody has a vacation, you don't make a big deal out of it. You say, "Okay, tell me when your vacation is. When are you going to go for training or whatever? We'll skip that time."
Right.
I think being decent about scheduling is just something that's really very clearly right down Main Street on Civility. Okay, continuances and extensions of time. That's Cameron.
Yes, thank you.
We sort of touched on that already, but keep going.
You know, I think about the scheduling in Orange County. We had 7 defendants. So you can imagine we go into chambers and try to set a date. And I said, no, I'm going to be in Paris that day. What about you? No, I'm going to go to South America. Trying to get a date out of 7 lawyers was not easy.
Paris, California.
Yeah, well, it could be. The continuances and extensions. I like the idea that lawyers should agree to reasonable requests. Because what goes around comes around. We could need that extension ourselves. And that's part of professionalism. I like that word in here throughout. And courtesy. And in the interest of the client, that is throughout this, these materials here. Reasonable requests too, for extensions or continuances without having to see the court are good things to do. They are professional courtesy. And then they mentioned first requests for extensions or first requests for continuance. That's early stages, and that there should be cooperation throughout.
My recollection in Orange County was it was the judges that didn't like the continuances. And they get no further continuances or whatever.
Yes, I would hear that.
Your opposing counsel was fine with it.
Well, then sometimes, you know, there's no good bum on the other side, and he won't grant any continuances. And, but I don't think people find out about that. Is not cooperating and trying to grant continuances, and in the interest of resolving the case too. So maybe if we continue one more time, there will be a reasonable discussion for settlement.
Plus, in criminal cases, our opposing counsel can't grant a continuance; they can only agree to it.
Oh, all right.
Because a lot of this stuff in the civil cases, I understand, is outside of court, and you have to agree together.
Yeah.
Because we would just agree or not agree, and then go and pitch it to the court and see what happens.
Yes. And then mentions here, reasonable lawyers. It does not engage in the strategy of not agreeing to reasonable requests for time and extension, simply to appear tough and advises clients against such a strategy. So that's just find yourself in that situation.
Anybody had any bad experiences with this? No one? Well, Claudia, tell me what you had.
As far as like a continuance, I was just rotated into collaborative courts in May. I had just come in and taken over somebody else's caseload.
Tell me what collaborative courts is.
Collaborative courts is drug court, mental health diversion, home court. So you try to get the client into
We're supposed to be collaborating, right?
It's supposed to be collaborative between probation, district attorney's office, public defender, the courts, everybody, behavioral health. So I came in, there was a formal hearing set for one of my clients that was just assigned to me. I had just met with him that morning over everything. I was just getting familiar with the case. And the DA came in and said, well, we're ready for the formal hearing. I said, well, I'm gonna ask for a continuance because I'm not familiar with the client yet. I haven't read the motion. And for whatever reason, I don't understand. I think it's because I was gonna do a supplemental. That was my intention. And he felt that it would probably be granted. So he was just objecting to a continuance. For no reason, just because the motion had already been filed and he was ready and defense was supposed to be ready.
The argument your office has had this case for 2 years, even though you just got it yesterday. You hear that one all the time.
He didn't even make that argument, other than the argument was because normally in collaborative courts, defense will file its motion, and it's very common for the DA's office to wait at least a year to file their opposition. because they're overworked, they only have one person on staff, they're getting records, and because if the client wants to be considered for mental health diversion, then they have to continue waiting time. There's nothing that says that it has to be within a specific period of time, they lose that right. So we've had cases where, actually, I just had a case where our motion was filed last March. The case is from 2022. The DA was not ready 2 weeks ago, and my client passed away. So that's how long these cases can drag on. So finally, the judge said, you know, we're not gonna do this anymore. But this was back in May, and I had just come in. And the DA just objected to another continuance, even though he was very aware that I was just coming in for the first time.
Like Judge Sylvia Luttrell, one of our new judges, the other night in one of the panel discussions with the judges said, she hates old cases. Like, it's your fault that the case is old. Because something goes through hands and things happen and all that. The COVID thing is not really relevant now, but it was for about 2 or 3 years. I heard we're up to about 2,000 cases ready to go to trial with no courtrooms. So people kept showing up, and the clients got used to it. They just wouldn't show up, or they'd show up late or whatever. And it's just too bad, because now there's a very intense look at any request for a continuance, and there must be good cause.
Hey, John?
Yeah.
In this section, over 48 years of practice, I practiced by the Dick rule. Anybody know what the Dick rule is? The rule was that if my opposing counsel is truly a dick, other than that, I would provide extensions or continuances because it was easier, and promoted comedy and promoted collaboration. And the courtesy, most people responded accordingly, and it invariably would lead to a resolution of the case. If they were just total dicks, excuse me, then I would still issue, at least allow a continuance or extension, but that would be it. So it was just easier on me to be courteous to opposing counsel. Other than that,
Yeah, what are you gonna get if you force somebody to do something not ready to do? You're gonna have a problem anyway that's gonna
Right.
continue.
right?
Well, so basically, I think it's an attitudinal issue, isn't it? Is your overall attitude, if there's a need for a continuance, no problem? Or is your overall attitude, I hate everybody and everybody who looks like you, and no, the answer is no for everything? Sometimes we see those folks.
You know, this ties right in. Number 5 regards the Dick rule, I believe.
It's a little known rule. It's
Does
a
not
little known
condition extensions on terms which alter the rights of the parties in litigation, such as the right to demur or move against a complaint and so on. So conditional continuances are not favored.
Yeah, if I do one, will you do me one?
Yeah.
You're those like two, you owe me one or something. All right, well, I mean, that's a big part of our practice. I'm sorry to say, I hate going into court for continuances. I like to be in trial or do something that's an official, act like an arraignment or something.
And even the courts don't so much like continuances.
Yeah, they go, oh, this case is 4 years old. And there's a whole history, and it
Yeah.
came back and it was filed and dismissed. And I just had a case the other day that settled after 5 years, a misdemeanor. It was a hung jury a year and a half ago, and the district attorney's office couldn't get around to coming up with whatever. I mean, we kept making them offers. Well, make it a misdemeanor. Make it a disturbing the peace. Make it a battery, whatever. It was a sexual harassment, some kind of case, sexual battery that required registration as a sex offender. So I said, we're not doing that. If we have to, we'll try it again. They said, no, I'll take it to our supervisors. We'll have a staffing. I'm thinking, how hard is this to just make an agreement and get it over with? Well, we finally got it done a year and a half after a hung jury on a misdemeanor. Just stupid. Just kept showing up. My guy was driving up from Orange County too, which is really bad. So it was bad for him. It was bad for everybody. And it was clogging up the courts. for no good reason. All right, so continuances, so be good, be decent, be reasonable. How hard can that be? Service of papers. I'll need your help now because you're a civil guy, you can tell me about it.
Yeah. Do you want me to read the section then?
You can do that.
Yep. The time and manner of service of papers should not be calculated to disadvantage or embarrass the party receiving the papers. Specifically, a lawyer who manifests professional courtesy and civility, 1, does not serve papers simply to take advantage of an opponent's known absence from the office or at a time or in a manner designed to inconvenience an adversary. Sucker. 2, serves papers by personal delivery or facsimile transmission when it is likely that service by mail, even when allowed, will prejudice the opposing party. 3, serves paper on an individual attorney known to be responsible at his or her principal place of work. And 4, refrains from using the mode, timing, or place of serving papers primarily to embarrass a party or witness.
Well, who has problems with this subject?
Yeah.
I don't know, every once in a while, we get a case refiled, and nobody tells us about it until we get there.
I mean, generally, the whole purpose of service is to put people on reasonable notice that there's an action pending against them, whatever form that action is. And don't weaponize service to try to gain a civil advantage or other advantage against opposing party.
I had a law firm that I started getting a lot of cases from. It was a defense lawyer. It's a plaintiff law firm in Beverly Hills. And what they would do is they would file the summons and complaint, and then on the appropriate day when they could actually serve the defendant with discovery, they would serve the defendant personally with request for admissions, request for production of documents, form interrogatories, special interrogatories, and a notice of taking deposition. And you know that a defendant who doesn't even have a lawyer yet, doesn't have a clue what this stuff is, so they don't do anything with it, and then they send it into their insurance agent, who sends it to the insurance company, who then hires defense counsel, and by the time the case will be assigned to me, the time to respond to any of these things is long gone, and they wouldn't grant extensions.
And then those continuances come to bear?
Oh, everything comes to bear. Then you start saying, if this is how you're gonna play it, then we'll try every single case. Because it was so unprofessional, and they routinely did it on every single case.
Yeah.
And it was to gain an advantage, and they did.
Exactly.
It was horrible. And it's a well-known plaintiff law firm in Beverly Hills, and that's how they practice law. It was disgusting.
But what I would do in cases like that, when I would get served with papers, but that kind of stuff, it's totally meant to harass
Of course.
and to hopefully increase your opponent's costs of litigation. My first call would be to the lawyer and say, look, I got served with all the discovery. I said, because I'm usually plaintiff's counsel. And I said, my file's open, what do you need? Just let me know what you need, and I'll give it to you voluntarily. Let's put a hold on all the discovery. And then if you don't like what I give you, then we'll respond.
But you and I have been practicing law a long time. That is the best way to do it. I do the same thing. I
Yeah.
started then doing plaintiff stuff like 15 years ago.
Yeah.
Exactly. Anything
Right.
you want, you can have.
Right.
And I'm not trying to hide anything. Here it all is. I was
Right.
trying to resolve it. But it's when they play games. And when they play games, I would use the Dick rule too. This is how you're going to practice. And you're going to try to embarrass me to my client, namely the insurance company. And I'll make you a promise. And I would generally say this. Have you ever tried a case? And most of the time, the young lawyers say no. And I said, well, you're going to be trying your first one against me.
3 times I've been served on Christmas Eve.
Oh,
And there's no doubt, we talked yesterday about the client's personality is now being amplified through the attorney.
exactly.
Anyway, it's
Yeah, it's disgusting.
We have rules in the criminal practice that you have to give any information that supports witnesses and materials that you're gonna present in trial 30 days before trial. So what happens is in the middle of trial, we get things, and you have to whine about it a little bit. There's a late discovery instruction and all that. Both sides do it, by the way, because they're working in the middle of the trial and they find stuff and they develop it, and so they want to present it.
Yeah.
And I suppose that's relative to this. It's that's one of the few rules we have in the criminal practice as far as Excuse me, I'm giving Irene something.
Oh.
For your own benefit. Thank you.
It's all about us.
For your benefit. So, other guys that do civil practice, have you got horror stories about this stuff? Can they serve you by email?
Yeah,
I mean, under the Dick rule, I mean, I serve people by either email or by mail, and got no response, and would end up taking a default. And then even after I got a default judgment, I get a call from a lawyer, the lawyer, and he says, "What's this default? I never got served." I go, "Well, yeah, you did." I'd send him a copy of the certified receipt or the service by email. He says, "You know, you can show me everything you want." I never got it. In most cases, unless I'm operating under the Dick rule, in most cases, I will say, okay, and I said, "Send me a stipulation, I'll set aside the default."
That's the right thing to do.
Yeah.
I hate to say this might pet peeve, but people tell you, "I sent you an email, didn't you read it?" And I'm thinking what I want to say is, "Hey, jerk, you think I sit around waiting for your email? Call me, let me know that you did it, and I just send it and expect that it's in my brain." And we get videotape all the time with a stupid application you can't open up, and you have to fight with it. And then that's discovery for you. You got it. And so some of that stuff is annoying, but whatever you're gonna do.
You know, as we were talking yesterday, I forgot his name, but the gentleman who's talking to us about substance abuse and stress. Yeah. This is just one area that it's so easy to eliminate that amount of stress in the daily practice of law just by being courteous or extending courtesies not have to be anxious or stressful about how you're going to poke them in the eye or how you're going to take advantage of this or you go into war over a stupid discovery matter or something that's really ridiculous.
I think, John, you said, isn't it just, it's so easy to do. Why people have such an aversion to using the telephone? It's the simplest thing in the world. Pick up the phone and call somebody.
Call and say, "I sent you an email at 2 o'clock yesterday, did you get it," or something, if it's really important. Well, here's my attitude, a universal attitude. Some people have the answer is no before they even hear the whole question. My view is everything is yes, as long as, yes, as long as there's a contingency, as long as I can do this, or as long as I can have a day or whatever. It's a much easier way to get along. Because kids and spouses and everybody else ask you for things. There's some people that just orient toward no. Nobody wants to hear that.
Mm-hmm.
And so I think the answer is yes, as long as we meet the conditions for the yes to be provided.
We talked yesterday about age differences, and I find a lot of new attorneys don't have telephone skills, and they want to use WeChat or Instagram, which I don't have.
Yeah, I just had a case with
Sign of the time.
tons of messages on WeChat, and I'm thinking, what the hell is this?
WeChat.
I never speak to opposing counsel by phone, ever,
Really?
ever.
You can't, because you're a PD, you couldn't answer all those phone calls.
Well, but we never call each other on the phone. It's always email or text.
Yeah.
Everything's by email or text.
I found it, like with the lawyers that I deal with, the experienced lawyers that have been around, they're so easy to deal with. I hate to say this, it's the young lawyers that feel they have to show they can fight, they have to be tough.
That's true.
And you want an extension? No. And you give them an extension to respond to discovery, and you get their responses in, and it's all objections, and you go. It's so annoying.
Years ago, people would tell me on certain kinds of cases, mostly civil, that they would call somebody and it would just be a litany of cursing on the other side. And so then they quit doing it, they just sent them an email or whatever. And I don't know why anybody would do something like that, but there are those people who think that's the way to intimidate or whatever. I guess that's what it is.
There are people out, I had somebody call my office and do that, and they were using very disgusting language on it. I don't know whether it was a receptionist or a paralegal. And I called, I said, have you ever used use that kind of language.
Right.
Any,
Not right.
if it's employed by me.
Yeah, they're
use
abusing
the
your
regret.
people, that's just awful.
It is.
I had a friend in Orange County, I forget who it was now, had a bullshit stamp. And he gets stuff in the letter that he didn't think was so good, send it back. That was a little bit much and not quite civil, but sort of funny. Okay, Jordan. Tell us about communication. That's what we're talking about, right?
We skipping punctuality?
Punctuality first.
I'm sorry. Yeah, Steve, I'm so sorry.
No worries.
Punctuality screwed up here.
Yeah, well, you were late. This section's pretty straightforward. Be on time. Don't be late. A lawyer should be punctual in communications with others and in honoring scheduled appearances. Specifically, a lawyer who manifests professional courtesy and civility arrives sufficiently in advance of trials, hearings, meetings, depositions, or other scheduled events so that preliminary matters can be resolved. Timely notifies all other participants and the court when a reason beyond his or her control, the lawyer will be unavoidably late. And timely notifies other participants and the court when he or she is aware that any other participant will be late for a scheduled event.
Good. I always feel, if you're not 15 minutes early or late. I used to bug Claudia about that, but she's on time all the time now.
No.
And I think it's important to be on time. I don't know, I've just got a psychosis about that. You can't be late. I hear people say things like, my time is worth a lot, and I think, oh, that's crap.
It is.
But you just don't want to offend somebody or be rude to somebody by not showing up on time. That gets me in the gut. Anybody have any comments on timing?
Well, sometimes you just can't help it,
Yeah,
you
just got a call.
but makes a call. Say, I'm gonna be late.
Yeah, if you're gonna be late, if you call, at least you're giving yourself
There's
some sort of.
There's a song by Van Morrison, going back 1970, and it deals with professionalism.
What is
It's
it?
just a professionalism. So here you got a ballad from Van Morrison, and I'm in law school, and I hear that professionalism is just completing the work on time. And it was just so simple, and it was poetic, and it had a melody to it. But it was
He's
a
a lead
guiding
singer for
force.
them.
Huh?
Ben Morrison's the best.
Well, it was very strong. It was a strong message, and I always, when people would accuse me, which was sometimes more often than not, that I'm behaving unprofessionally,
Huh.
I thought, okay,
But you're on time.
I was on time.
Do you break out in song?
I can, but it was probably in Moon Dance. So you'll have to listen to every song and it's a hit.
Uh-huh.
There's no bad song in Moon Dance.
Yeah, Van Morrison was one of my favorites. G-L-O-R-I-A, go.
That's them.
That was
So-
Jim.
Who's the lead singer?
That was Jim Morrison.
Back when they first came out here,
What's that?
were you a Dodger fan when they first came out here?
Yeah, and then I switched to the Padres in
Oh,
'69. I was in San Diego, and then I came back to the Dodgers, so there's a lot of confusion there.
When I was a kid, my grandfather used to run buses up to the Coliseum, because I played in the Coliseum when
That's
they first got here.
Yeah,
Wally Moon had the moon shots, you know.
Left field.
Short left field pass.
Yeah.
260.
yeah, that goes back.
My dad took me up to see the Giants play the Dodgers and the big fights between Juan Marichal and
Oh, yeah.
Oh, don't
Johnny
go there.
Rivera and,
I'm a transistor radio kid. Listening
Yeah.
to Vin Scully. And
yeah,
I took my radio to the stadium
really?
to listen to Vin Scully.
Did you know that there was an Angel Stadium in downtown LA?
It was called
Yeah.
Wrigley
Wrigley
Field.
Field, exactly.
Yeah.
I remember going there thinking, what a weird place.
Yeah.
Walk into the third level and,
I used to think, what does chewing gum have to do with the Angels?
yeah, exactly, just the money. Plus he owned Catalina for a while.
Yep.
And the Cubs out there on the backside. Okay. Steve, that was great. We know we're all supposed to be on time. I think time is so important in our profession. I don't believe in counting the number of minutes you spend with somebody as a client, I think that's sort of weird. But, I think about it when I go to the doctor's office and wait an hour and a half to get in for my appointment. And I can't do anything about it, and I've got to see the doctor anyway. Irene wants to go in and rant and rave, and I just say, man, look, that's it, this is what we're stuck with. But we think, why would you say be here at 10 o'clock if you're not seeing me till noon? What's that about? And it happens almost every time the doctors I go to. They must be good doctors because they're busy. Okay, now George.
Okay. Morrison reminded me, I'm into robotics at 4 different high schools, and we use a term, gracious professionalism.
Say it again.
Gracious professionalism.
Gracious.
And to me, being civil is, don't make it personal, and keep in mind any memo that you write, is there any way it can be used against you in 3 or 4 years? You need to view it in that light. Also, in my world, your opposing counsel 6 months or a year from now could be co-counsel. Don't want to alienate them. The bridges are not to be burned. You want to be factual. And I think of Joe Friday, Dragon. Just the facts, man.
714.
Don't elaborate, and in the same vein, don't create a false narrative. Everything has to be tied to the record somewhere. I think it's important to be concise. And I think the best way to remember that is don't allow yourself to become completely intoxicated by the overexuberance of your own verbosity.
Nice line.
Yeah.
Well said, well said.
Don't attack opposing counsel. Like I said, keep it on the true and narrow. Reference letters very sparingly. You want to use evidence on the record, not necessarily very deep personal letters. And along that vein, respect confidential data, and probably that should never come in unless it's approved by the judge.
In the criminal practice, we see the same DAs all the time. So if you try and mess with them one time, you're going to get it back the next time. You got to be very careful. You got to be kind and decent. I think that's why criminal lawyers are very easy to get along with anybody else, because we see each other all the time. And look, all lawyers are highly educated, decent people to begin with. And even the district attorneys. And many district attorneys end up changing sides or going into another law firm or something else. But you see them on the same kind of case in 6 months. And if you pulled a fast one on the last time, you're in trouble. Because they'll be wary. And also, I think our communication is mostly verbal. There's some that goes on with letters and emails and all that kind of stuff, but a lot of verbal communication. And that personal attack stuff is just awful. Especially in closing arguments when they say stuff about you that's not nice. You remember that. I remember that.
Yeah, on some level, in my experience anyway, in general civil litigation, the underpinning of most litigation is because the parties are unable to communicate.
Or what?
Are unable to communicate.
Yeah.
Instead of articulating the dispute, that's why mediation is such an effective tool these days. It forces people to communicate when they can't do it on their own. And I've always had these conversations with opposing counsel. I said, listen, let's talk about what we need to talk about, try to resolve the dispute. We can always throw paper at each other and bill our clients money, but otherwise let's talk and get it done. And most of the time you find that's why mediation is so successful, because it forces people to talk.
One of our good friends, Karen Sloat, said that she got from another lawyer whose name I don't remember, that when she has a new case, she'll go and get coffee and take it over to their office and ask them if you can have a little conversation. She said it's unbelievable the difference in the atmosphere for communication.
Right.
That's an interesting thought. I like to invite DAs out to lunch or whatever, but a lot of times they think, it looks bad, it's wrong. So it doesn't always happen. I have these pens that Irene gives me all the time. Everybody shows me, "Guy, can I use your pen?" I said, "I keep it." I don't know if I can keep this. Let's set a CBPA on it. I pass out my pens. But we do get referrals from the DAs, which is nice. To the law school. All right, so let's see. Rod, this is a big section.
I was gonna say, when I saw
You're the
that,
man.
I knew it, I got the big section. And it's obvious why it's the big section. Discovery in civil practice is a weapon that a lot of law firms and lawyers use to just harass the hell out of you.
Well said.
And I gotta admit, when I started practicing law, I was a prosecutor back in '76. And, discovery is way different in criminal than it is in civil. And when I went into private practice with a law firm, and they started giving me civil cases, I couldn't believe reading the Code of Civil Procedure that you could do all this crap. That you could take depositions and get documents and all that. And I was like a kid in a candy store. I just abused the hell out of the process because I thought, wow, this is a chance to learn everything about them, including what they did bad when they were in kindergarten. And you realize, that's stupid because then you got to look at all that stuff and you're fighting with them. But discovery is just a hellish thing, especially when you're against a lawyer who's just mean-spirited. It is just difficult. What I try to do when I first get involved in a case, I do call the attorney, always call them, and tell them, look, ask around, I'm an easygoing guy, I'm accommodating, I'll give you what you want, we don't have to do this, and by the way, if you're inclined, I'm willing to discuss mediation with my client just to start the case. And the reason is, it may be a lot cheaper for them to get an arbitrary settlement that they agree to than it is to litigate the thing before going into mediation when their attorney's fees have been mounted so high that nobody wants to settle any longer.
Didn't you talk to us about criminal mediation at one point?
I do. It was an idea that I came up with a few years ago. I decided I wanted to try mediation, so I did the program at UC Pepperdine, or at Pepperdine University, the Strauss Institute. And one of the seminars was on how to say you're sorry. And you learn a lot, parties in a lawsuit are so angry with each other, and sometimes all it takes is somehow communicating to the other, I'm sorry. As criminal lawyers, we can't let our clients talk to these people, but there are, and say those things, and eventually at sentencing, the family of the victim will say, that person didn't even have the decency to call me to let me know that they were sorry that they killed my son.
Remorse.
Yeah. So it occurred to me, if it was a proper case where my defense isn't that he didn't do anything wrong, why not get a neutral like a retired judge and ask the other side, let's mediate this, let's put this in front of a mediator, a retired judge, to take some of the heat out of the case. And especially in vehicular manslaughter type cases, I did that a lot. And there were a couple of judges out here that I used to do it. And it was very effective from a criminal defense standpoint, getting victims' families to be less vociferous in their insistence that the client, be put to rest or put in prison for the rest of his or her life.
Does the district attorney's office agree to this kind of mediation?
What?
Does the DA's office agree to mediation?
Not often, but usually the civil lawyer handling the civil end of the case will agree to do that.
Good point.
Because they know then that we're dealing with somebody who's willing to work with the insurance company as well to say, let's get this thing put away.
And it's free discovery too,
Oh yeah,
without the paper.
that's right. And so the other side learns the feelings. There's a split of authority whether or not that's discoverable if the DA is not involved. there are some cases that hold that it is still confidential, and you can't use that information for mediation in the criminal prosecution. But
Offer to negotiate, right?
yeah, but in those cases, we usually don't care.
I had an interesting case in Bishop. That's a long ways away from here, by the way. A gypsy lady had got a lot of money out of a woman who was an Italian woman. And the Italian woman was wanting to go get a prosecution underway, but the prosecution hadn't come across yet. They hadn't decided if this is the kind of case they want to take on. So we set up a meeting up there, and we went in there and got all in the same room. And the lady said, the Italian lady said, I want her to remove the cornuto. And I said, what's that? And that's some kind of a threat or
Curse.
a curse or something like that. And I said, really? So I talked to my client. It was a big deal, but she finally said she did it. And that was it. That was all the lady wanted. She wanted to have a prosecution just to see if she could get her money back or get the curse taken away. Weird. And Bishop is up there by Manzanita. You have to drive by it in order to get there. What a weird place. I had a jury trial there too, with a drunk driving case. And the courtroom was so small, the jury had to walk out from the jury box behind the counsel tables to get out. And at one point in the trial, I don't think it was the best point for me, walked by and one guy said, don't tell your client don't ever come back up here and drive like this again. And I thought, well, that's not sounding good for the jury, is it, for me, or for my client? It was an interesting place. They had a whole scene, but Independence, California, I guess is what it was. Very interesting. Well, okay. I hear these horror stories about giving you a truckload of evidence when you ask for discovery. I've never been involved in that myself, but it sounds really weird.
It is. I had one case against the Japanese corporation. I had a large law firm out of LA, Paul Hastings and Oski, on the other side. I made a request for written, for production of records. They sent over 1,300 boxes, 1,300 banker boxes. We had to rent a room, an office, just to put all those boxes.
Weren't they like a work comp firm or something?
Mm-hmm. Paul Hastings, no, they're one of the heavy hitter litigation firms.
Back in the day, I had something to do with work comp.
But it goes to one of the things they talk about here in production of records. That firm was hiding about 3 or 4 documents they didn't want us to see. And then we found them. And
You had
then
to
we
dig
went to
through to
trial.
find them, huh? You had to dig through to find them?
Yeah, my client was a determined man, and he sat in that office every day for months, and he found them. He found the documents.
Wow.
And
Wow.
we went to trial in federal court and got a nice verdict.
Wow. All right, Claudia, it's time for you. Motion practice.
Yes, section 7, motion practice. I'll read it first. Motions should be filed sparingly, only in good faith, and when the issue cannot be otherwise resolved. Specifically, a lawyer who manifests professional courtesy and civility, number 1, engages in more than a mere pro forma effort to resolve the issue before filing a motion, and when appropriate, will certify in the motion the offers to resolve the issue. Number 2, the lawyer does not engage in conduct which forces opposing counsel to file a motion unless intending to oppose such motion in good faith.
Any experience you have in that, Claudia? The motion practice? Probably not, but who knows?
Very limited. I mean, just issues, discovery issues. A lot of the time when you keep emailing, talking in court to the DA, asking for additional discovery, and
Motion to compel.
a motion to compel, yeah, once you've talked to them in person, you've emailed them, and you still don't have the discovery, you're getting close to a trial or something, and you still don't have that. That's probably the extent of it. I haven't dealt with too much of the other issues.
I think we're pretty congenial over the criminal courts about, you know, you gotta give me this, or you sent me this, but I can't find it, can you give me this document or whatever? Most people are willing to cooperate.
And yeah, and my experience has been that if they haven't produced the discovery, it's not because, it's not in bad faith. It's normally because, oh, I reached out to the agency and I still don't have it, or I'll reach out again, I told my assistant to provide it. It's never been a really bad
It's
issue.
always those darn cops. Okay.
Yes.
This next one I didn't assign, dealing with non-party witnesses. You wanna leave witnesses with an appropriate, good impression of the legal system. Professional courtesy of those people for depositions and all that. Okay, where this comes up with us, mom and dad pay for the kid's lawyer. And now, do mom and dad get a right to have a copy of the kid's materials? Now, let's get to this out. And sometimes relatives or other people. Excuse me, Irene, I had a quick consultation.
This qualifies multitasking.
That's it. Thank you. Yeah. So, I'm sorry to interrupt that in that place, and Irene is just continuing to work. So parents want copies of their kids' reports, aunts and uncles who pay for their nephew and all that. And we always just basically say, is it okay with you if I'm made available to your family? And if our client says, yes, that's fine. Many clients don't want that to happen though. They don't want their bad behavior to be seen in real color by the relatives or whatever. And I guess the point of this section here is that you ought to be courteous to people who aren't parties to your case, because word gets around. It's amazing if you treat people poorly, other people know about it, other people find out about it. Plus, if you're seen to be in that kind of behavior, court personnel sees it, etc. And we gotta be really careful with court personnel, because they're the people that can make your life good or bad, easy or not so easy. I remember one clerk in Orange County when I was a young lawyer telling me, when somebody comes in and gives me their card and tells me how important they are, I put them at the bottom of the stack of files, because they're usually from Century City. She said, it happens. We used to be able to give a little gift at Christmas time, a little jar full of M&Ms or something, and then they outlawed that. People actually can't do that because it's giving a bribe or something to court personnel.
I just did that.
I was thinking, that's ridiculous.
Who'd you bribe?
The clerks.
You get John's business card.
I know.
I swear to God, if you get to know the clerk, your case can go close to the top of the pile of files. You know, you just gotta treat people right. I mean, it's so amazing that people treat clerks like they're their housemate or something, you know. You have to do this, get this, copy this, you know, and it's like, can you ask them in a nice way? Come on. Court clerks run the show too, don't they? The judges always ask them, what am I supposed to do next? Gotta be careful. Okay. Ex-parte communications with the court, Mike.
Okay, so guys, I haven't litigated in over 30 years.
Wow.
I remember dealing with this issue as a young associate for one of my partners. I can't remember if we made the ex-parte communication or we were responding to one. So let me give you my take on why I think this is written this way, then if you guys have real-world experience that can add to it, please enlighten me. But this is dealing with ex-parte communications on the substance or merits should be avoided where possible. But if you are going to do it, you should make diligent efforts to notify the other party and in the emergency situation, it should be a true emergency. So it seemed to me, just thinking about it, why this is written this way is that the risk of prejudice to the party not communicating with the court is high because the judge is getting only one side of the story on the facts, only one side of the story on the law. It seems to me antithetical to the whole jurisprudence system that the decision maker should be getting both sides of the story on the facts and both sides of the law. In my practice of insurance coverage, I'm going to mention something Don said, it is way too easy to make an argument to the court that this term of an insurance policy should be interpreted this way, and you can very easily skew the argument to lead the court to one decision, but then if you look at it a different way, it can lead to another decision.
What companies did you work for?
Well, I worked for a large law firm called, it's funny, my guys came from Paul Hastings. So we represented only policyholders in coverage litigation. And
Say it again, what?
we represent only policyholders for very large corporations
I see.
suing insurance carriers. And then I was working for a big coverage firm called Hillman, Troop and Licensure. But anyway, it would just seem like the party who is making the ex parte communication is too easy to represent the facts in a certain way that to lead the court to the wrong conclusion. So that's why it should be avoided. But if you have to do it, it should be a true emergency, and you should make diligent efforts to contact the other side. But I would like to know, does anyone have like real life experience where your client got screwed because the other side made an ex parte communication and you didn't know about it, or you weren't there and then the court made a wrong decision because your client's views weren't fairly
What about
represented?
the generic kind of ex parte communication where it's not directly on point of the case, but you're watching the football game with the judge, or you're having lunch with the judge, or whatever, and sometimes your cases might come up. We didn't try to do that, but it just happened. We have a real dark, clear red line between social activity with judges, especially the judges that might be hearing our cases. And what do you think about that?
Early on in my career, I used to play poker with them.
Yeah. Illegal poker games, I love it.
Yeah. And with deputy sheriffs and all the people who are committing crimes are not reporting it. But we never talk about cases.
We play athletic events, racquetball, volleyball, and all that together with the judges, and sometimes a case would come up or a thought would come up, and you try real hard to be careful about that, but that could happen. I think now judges have to report any personal contact, especially if there's anything involving value. Like you can't invite the judge out and pay for the dinner, or you can't go to a movie or something like that if you pay for it, even if you don't pay for it, because it's potential for misconduct. And it seems like that's sort of unfair. Seems like sort of rotten. You can't be friends with a judge, but I guess you can't. You don't want to know anybody. I know the judge like John Evans used to recuse himself if some case came before him. That was one of our students that graduated or whatever, or me. He would just say, I teach over there, and I don't have any personal interest in this because whatever. That kind of stuff can come up. I know Judge Elizabeth Tucker, informs people that we're in the same Rotary Club together. Feels compelled to do that. I guess that's what you're supposed to do. You just wonder how things get that way. All right. Are we on number 10 now?
Yep.
Gabriel.
Section 10, settlement and alternative dispute resolution. In every case, a lawyer should raise and actively explore the potentials of settlement or alternative dispute resolution as soon as the case can be evaluated, and if feasible, mediation should be encouraged. Specifically, a lawyer who manifests professional courtesy and civility 1, advises the client at the outset of the availability of alternative dispute resolution. 2, does not falsely hold out the possibility of settlement as a means for determining discovery or delaying trial. 3, considers whether the client's interest could be adequately served and the controversy more expeditiously and economically disposed by arbitration, mediation, or other forms of alternative dispute resolution. Settlement, to me, is probably all. I mean, I don't know what the numbers are. I can be reckless and say 90% of cases filed are settled prior to trial.
Well, it sounds like an advertisement for alternative dispute resolution. but
Exactly, yeah. And when
I suppose if you can figure out a way to settle it rather than try the case, it makes sense to do that.
yes, and I think the key point here is to disclose this and to provide advice on the different alternatives to trial and litigation at the outset, as I read, and that should be an important part of the interview. In my case, it's face-to-face with plaintiffs and or applicants in my business, workers' compensation. And what I don't see here, and I'm not sure in civil practice, whether informal conferences are encouraged or allowed, specifically informal settlement conferences. I can speak to workers' comp. One situation I had where a field of farm workers or a group of farm workers were exposed to airborne pesticide during their lunch hour. And it was in Ventura, big strawberry area, harvesting area there, and I had 25 clients that I signed in mass. And we settled probably 20 of them in one afternoon. It was by informal conference, and I thought it was so efficient and so encouraging. Everybody was invigorated. And it was just an anecdotal experience I had with regards to this topic. But I think informal settlement conference go a long way. It should be more encouraged.
I think we could all agree it's better to settle than to litigate,
Exactly.
but it's got to be a fair settlement. Judge Wells here and Sheila Williams have this mediation firm for family law, which I'd never heard of before, but apparently they can do a good job for you and cost less than paying through the nose for divorce lawyers. I heard this too from an old partner that I had that was a divorce lawyer that said nothing prevents the parties from getting together. So the husband and wife, they go get together independent of their lawyers.
Yeah.
And there's no violation of the law or violation of privilege or anything, and try and work things out. So she would definitely recommend try and work it out, what you can do with the kids, and come back and present it. Because if you fight over this, it'll cost you $5 or $10 grand, and you're still not gonna get anything better than what you already got. So, yeah, I think settling is always better than trying, although I love trials. I think trials are the best thing we do. And I love being in trial court because I know what side I'm on, I know what I'm supposed to be doing, and having an idea what the evidence code provides is good. I've seen many criminal lawyers go into family law because they have the evidence code and they know about it and they know how to litigate without juries. It's scary to me still, family law, it is. A good friend of mine that was a DA out here, or assistant DA for a long time, I don't know where she is now. Her father was killed by a family law litigant, came into his office and shot him in Orange County. Brought a big old gun and just shot him. And I hear that family law lawyers get attacked more often than any other kind of lawyers, which
Believe it.
sounds like that's the lawyer taking on the client's attitude. That's just scary. Okay, Rashid, trials and hearings.
Well, it's just a brief comment about trials. We cannot try every single case. A lot of cases have to be settled. In work comp, the average is about 90% cases get settled, or 10% go to trial. Now, I was born in Pakistan, and I was 19 when I left. There are no plea bargains there. Every case goes to trial. And sometimes it takes years for a case to go to trial. And then in the meantime, the defendant is sitting in the jail without having resolution. So and that is inhumane in my view, especially in capital punishment cases. And that happens. Now, there are several things involved here in trial and hearings. Number one, an attorney should conduct himself in a manner that portrays a positive image of the profession. And we all know that we have to be courteous, we have to be kind, we have to be fair. One thing I would add to that is that we should not be combative. And I see a lot of attorneys combative. Witnesses, with lay people, sometimes with court personnel. That is improper conduct. I would also add attire. At WorkCom now we are doing all the pre-trial hearings by Zoom. And I see attorneys appearing in photos. They don't even bother putting on a tie. I think that's improper. That does not put our profession in a positive light.
Have you ever heard the suggestion that we're supposed to refer to witnesses by their formal name? Rather than, hey Bob or Kenny or whatever, yes, Mr. Jones or whatever.
Right.
We just had a trial where our client's name was Kenny, and everybody referred to him as Kenny. And we're in the courtroom talking to Kenny and directing cross-examination. I'm thinking, that just doesn't fit right.
It's not.
It's not as formal as it should be.
Right.
Okay, what else?
Be punctual, be prepared. You see attorneys scrolling through their iPhones when the judge asks a question, they're trying to find a date or something. Be prepared. Review your case before you appear.
They read the question off the phone?
Always be nice and courteous to everybody in court, including court personnel as witnesses. And I see attorneys arguing with the judge, that's improper. If you don't like the ruling, file an appeal. You have that part of your procedure. File an appeal. Frivolous objections, that's another area. Here I have to tell a little story. There was a case that came out, went to trial in Orange County, and it was mid-90s. John, you may know that case.
Good job.
People versus Dr. Thomas Jones.
Yeah.
He was married to John Wayne's daughter, and when they divorced, he hired somebody to beat up her boyfriend. He was accused of and convicted of it. So what he did was he went to New York and found a
Bruce Cutler.
Found Bruce Cutler
Bad guy.
from New York. And I'm sitting in the courtroom, and every time the prosecution asked a question, I would see Bruce Cutler stand up to object. Every single question, he objected to every single question. That's improper. They say that you pick your fights carefully. So you want to only make those objections that you think are appropriate. And lastly, be honor requests by the opposing counsel. That comes up usually in the context of continuances. We always get requests and we honor them. If it's not going to hurt my case,
Sure.
I'm fine with that.
I've been requesting to come into court late sometimes, because I gotta go to physical therapy. Nobody bitches about that.
Yeah, absolutely.
It's not that I want to, but they tell me I have to. The objection thing though, Pete and I talk about this a lot. First of all, just because you can make an objection, it's not a good idea to make every objection. Some people don't know how to ask questions, and they prove it to you in the courtroom. But if you're just making an objection because it's a technical objection, you're probably bothering the jury and suggesting that you're trying to hide things or whatever. So, the objection thing about good faith reasons. I guess any good objection is a good faith argument, although sometimes it's just a mistake to do that again and again and again. I remember Cutler out here was really a nasty guy because I was around there at that time. He took on another case where I had some interest. I had a nurse, a male nurse that was assistant to a guy who was a plastic surgeon down there. And it was a second-degree murder case. And my case went away after the prelim, but Cutler happened to be out there, so he hired this guy. This guy hired him. Just mean and nasty. I mean, the courtroom vibe was bad. And it was weird. And didn't get great results either. I don't think that. It's rarely getting good results when you're over-objecting.
Right.
I think being professional with the court staff and the opposing counsel, Pete and I talked about this in trial practice. The jury's looking at you. If you're behaving in a professional way, that adds to your credibility. If you're being a jerk, that doesn't add to your credibility at all. And
They're gonna like you.
the judge is the most important person in the world, and if you're fighting with the judge, you're not helping yourself. Okay, now I have privacy here, and I think I already mentioned this, but when you have a client, if clients, relatives, or other people want to have their discovery or look at it, you have to ask the client first. Private lives are sort of off limits. A lot of the social media stuff now comes up where people bring it up. And remember we talked yesterday about a gay man charged, or a man charged with murdering a gay man. Can you bring up that? If it's relevant, as it says here, if it's relevant, so if it's a relevant issue, then you can bring it up. But it's amazing how much stuff comes up in cases that don't have anything to do with the issues in the case. And some people make a living out of doing that. You just gotta be very careful, I think. Don't wanna be messing around with personal information about witnesses or about clients or anybody else. And there is a privacy right that people have, you know, you don't wanna violate that just because you are competitive and wanna win your trial. So the idea that something that's personal is available to you doesn't mean that you want to use it on the record. And it would seem unprofessional and uncivilized to do that. Anybody have any comments on that? One of my friends who's in the public defender's office had a case involving some woman who took some baby puppies and threw them in a trash can. And so she was prosecuted for this. And he said, puppies aren't people, because they were trying to set a bail. And they're saying it's 4 dogs and they're dead now. And he's saying, yeah, but puppies aren't people, and you can't set a bail based on 4 dead dogs the same as 4 dead people. And he got hate mail from all over the country for saying that. I laugh every time I see him. I remind him of that. But
He was in the newspaper.
gotta watch out what you say because the word gets out. We just had a case where a man was driving in his development and he saw another car run over a goose. And it was suffering, laying there on the ground, shivering. So he picked it up and he took it to the trash can. He was a 4-H guy in high school. So he took a golf club out and killed it. It was a mercy killing because he didn't want the goose to be suffering. And they had videotape of this. They didn't have videotape of the car that ran over the goose to begin with. And there were all kinds of name calling going on in that case. And finally it got resolved, but all that personal stuff had to come out about his background as 4-H and all that, because he said a regular person wouldn't do that. You'd try and save the goose. And he said, I evaluated it, the goose wasn't savable. It was severely injured, just trying to put it out of its misery. And that seemed rational to me. It didn't seem rational to the young district attorney who thought it was an awful, awful thing. And it looked bad on video, I gotta say. But they brought up a couple of things in the guy's past life which was not right. But it was resolved. Okay. So this is a stab at your civility stuff. You guys need a quick break?
Yeah, that'd be great.
Bathroom break, have a coffee, get back in here. I've only got till 10 o'clock, but I've got everything boiled down in this book I'm giving you for the second part about practice management. And we'll talk
Maybe
about
like that goose was cooked, you know? But I didn't want to go there.
Make it 10 minutes, okay?
10 minutes.
Make it
I'll finish this.
25 minutes to 10.
Yeah.
Cameron, how's Nina doing?
Oh, she's doing fine. I tell her about our seminars here.
Good. Did you tell her anything about yesterday?
Yes, I did. I talked about Mr. Dorst, is it?
I thought you would.
Yeah.
I was thinking about you as he was speaking. I was thinking poor Cameron. Cameron and Nina have challenges. But
Yes. But
he's something else, isn't he?
he's seen it all there,
To
man.
think about a
He
guy
lived
who's
it.
gone through that kind of trouble.
Yeah, she's.
Can you imagine having the courage to continue a trial when you're sleeping downstairs in the lockup?
Yeah, and cuffed.
Amazing.
I told her about that too. John, this has been enlightening, all these great speakers.
Well, we've got some, I've got one last thing. This book, I worked with this guy 10, 15 years ago. And he's a sales trainer. And I said, there must be some way that we can talk about the principles that you're talking about that apply to lawyers. And we talked and put together stuff. That's how we came up with this.
Thank you.
Explain that. And I've got a couple of formulas that came out of this. I want to explain.
Is that what this is?
Yeah.
Oh, good. I've kind
I
of
feel
flipped.
bad I didn't ask Irene to type it up until today. Because I was busy, dumbass.
Thank you.
You know, last weekend was the Four Tops and the Temptations.
Yeah.
I want to ask you want to see the Righteous Brothers?
Well, I have seen him a couple times.
But there's this new guy, the new young
Yeah,
guy.
Bucky,
What's
Hurd. Bucky Hurd.
So no.
Yeah, I mean, he's very good. He fills in very well.
Well, I remember Bobby Hadfield very well. He used to come to the Quiet Woman down there, corner of the mark.
Oh, yeah, yeah.
Bill Medley was one of Irene Sorrell's at one time.
Well, I've heard this. I've gone over there to Fantasy Springs and I've submitted my songs to Bill, because I kind of know.
Really?
Yeah, I said, would you get that to Bill? And so I've done it a couple times, I'm not gonna do it anymore.
I think it's the 17th of February,
Is it?
but I'm not sure. Let me look at the calendar here. Because I think you're gonna need him.
He's so talented.
He is. Bill Medley is quite a guy. And his daughter came and sang for him one time.
Oh, yeah, yeah.
It's not the 17th.
Well, I read his book.
I have no
It's
idea.
funny. It's well written.
Good book.
Yeah. Very down to earth.
He used to play the same place their little certain band was playing. The military bases. Remember El Toro and all that?
Oh, yeah.
Oh, boy.
Then they said, just go.
There's no record.
Thank you.
The Righteous Brothers, February 13th.
February 13th.
Have anything going on February 13th?
Maybe.
We're going to that death penalty conference down in San Diego. But we're not leaving until the following week. Well, I got a case down in Newport. Huh. You got anything going on in Harbor Court?
I'm going in on Tuesday,
Tuesday?
Orange County. Going to west and north. Can I appear for you?
No, it's on the 13th,
Oh,
so I can't advance it. So Deuce, where we gotta get a guy.
let me know, I might be going in.
Who's down there now? Brett London is still doing the calendar?
Yeah, I'm not sure.
Maybe that was the sepsis.
I'm going down there and find out.
God damn it, I'm not adversarial.
Yeah, February 13th. So ask me if you go. We wanna go. February 13th, I gotta go see the righteous class.
Oh, good, Travis been good.
Yeah, it's just so
Excellent. Well, wait, we're not here. No, we're in San Diego
I'm not talking about doing things.
on that Friday, yeah. Thursday morning, yeah. We're gonna call them up.
All in one year.
I mean, bring the baby.
Good. Hey, Cam, forget it.
Cameron, excuse me, we're out of town that weekend. We're
Sorry.
in San Diego for the Death Penalty Seminar. Mr. Romance takes me every year to the Death Penalty Seminar on Valentine's Day.
That's what he loves.
Nothing but the best for me.
What else would you want?
Well, it's like I take Nita to lunch, Temecula, because we stop at the jail.
Of course.
She waits in the car, and we go to lunch.
Well, at least you take her somewhere
Yeah, I do.
afterwards,
I do
yeah.
take her.
Put it on.
You haven't Temecula?
So I go to,
To the jail down in Southwest.
yeah, Southwest.
Yeah, I've done that trip many times.
Yeah. I think you find a nice restaurant.
A lot of nice places down there.
We
We went to
should
an
try
court
to-
thing down there last year. I forget what the winery was, but it was a beautiful, beautiful place. It was Wilson Winery. I can't go with
I
the
don't remember what it was, but the Desert Fire Association did was that joint venture with us.
Right, right. The joint meeting. They're gonna have this next month, the joint meeting again.
Oh, okay, well, good, you had fun.
Who knows, who knows? We gotta get in here at 25 till, so we can get going.
Okay.
Because Rusty, is he here yet? Well, I go overtime if I have to, but I don't want
You're
to.
supposed to go to 10.
I know.
Oh, okay,
10 o'clock is the limit.
yeah.
Just gotta get my formulas and tell them what it's all about.
All right, and you're welcome to, and, learn as you can, so.
I don't know if that happened. I asked Claudia if she would write down some stuff that she was talking to Donald about.
Yeah, oh yeah, we already talked about that. That'd be so great, oh my gosh.
So should that be like a little?
Yeah, exactly. I think that would be the best thing. Your roots, basically, and then, I guess it's the story that you told me, I think that was an idea. I was thinking, I wish I had heard the story, I said, wow, it would have been so perfect.
Yeah, I can definitely do that, and I'll talk to,
No, it's my son.
Yeah.
He raised all the
Yeah.
she's doing so well right now.
I haven't talked to her in several months.
She's working for Dolan.
Uh-huh.
It's on,
Yeah.
it's on missionary property. There's only 2 attorneys. And she is, so she's having to,
She has another name.
yes, she's learned so much. The only issue is that she works all the time. So she never says no, so she could be from like 8 in the morning till like sometimes 8 at night. They schedule different appointments for her, and she has no control over her calendar. No, and then she's working, and then they do workshops. So she'll go and do workshops out of town, on Saturdays. So I think.
Yeah, I was thinking about trying to work on this practice development stuff.
But she says that she's still working on baby,
Yeah.
she needs to prep for tomorrow, and she's always working.
And old Parkinson mentioned your name, saying, listen, get you going out here.
That was, it was funny. I don't remember ever meeting him. I believe we had a phone call, before, because he represented, Chris Ross.
Tell her
Chris
that.
Ross.
And he wanted me to testify in Chris' trial. And I'm like, nah, I'm not getting involved in
He was
that.
representing Chris Ross?
Yeah.
This,
And,
there's 2 different offices.
he comes in last Friday. We had a litigation team meeting there at the law firm. And
Yeah.
Sean Murphy, Brian Murphy?
yeah,
What do you got?
and Jim comes in and just starts
This guy over here, ooh, that's.
very complimentary of me.
But I
Oh,
mean,
Pete
as far
Nolan,
as
that
like,
guy right there, he
she
knows his stuff. He's a good lawyer. If you guys can learn this much, what he knows, I'm like,
She loves it.
I don't know you. Like, it felt odd being complimented by somebody you've never met.
I've heard about you, I go,
Yeah. And then after the meeting, he came up and he was like, hey, I wanna, I didn't even know what his practice area was. I just didn't know. And he's like, oh, I'm personal injury, and we're gonna start taking some cases out, and there's a huge market for that in Vegas.
Smart guy to do that.
Yeah. So I'm gonna loop you in, and we're gonna start doing that.
Yes.
Okay.
And her son is also.
I told you I missed that.
He's applying to.
When he came out, I said,
He
I think that's what
graduated
he's talking
from
about.
UC also,
He
and
comes from San
then.
Francisco. That was
Investment stuff, but I think he's thinking about doing law school.
how he really
Yeah, I think he was thinking about Stanford.
They get their money bigger.
What's that?
Jury paid up.
Yeah,
Oh, yeah.
So you have insurance on that.
I am.
That was a mistake.
I am. And it's gonna be, and they're gonna be pro first. Pro first.
That'll make it harder.
Little bit, yeah.
Or.
Not with the jury.
But Betty and her husband are pushing him to like, how we want this grant. But, and then.
Turn everybody back in here.
That's for sure.
You know, I like my way, I've been a lawyer for all these years.
Yeah, I'm gonna put this part in our trial practice.
Yeah, I think that's a good thing.
I'll look at practice.
I'll let her know.
I think that's a good thing. I've learned a lot this weekend for stuff to start including.
Yeah.
Yeah.
Crazy.
Cameron, have your coffee.
You want a coffee?
No, thank you, I'm good. Irene gave me Hey, who's not here?
No, she's good.
Child bride.
Yes, child.
It was very nice meeting you. Very nice meeting you.
I flipped through this.
15 years ago, I'm talking to this buddy of mine at the National Speakers Association. He's a sales trainer, telling people how to sell. And I said, God, you know, we lawyers don't really sell anything. And I guess we do in a way. We talk to jurors, we talk to clients and all that. And he said, you know, we should try and put a book together that could cover both territories. We knew a guy named Ken Blanchard from San Diego, wrote the 1 Minute Manager. In a story form, he would tell you ideas, principles on how to manage your business or whatever. And I said, man, we should do that. So we kept going back and forth, talking to each other. We made up this big story. And it's called The $1 Million Rainmaker, but I feel bad because it refers to money. And that's not what this is about. I want to read this little section for you from page 38. An old African once told me something I'll never forget. This is a guy, one of the characters in the story. I was a young man like you at the time, seeking the secret to developing business. He told me to look out the window. We were near a busy market and I could see it was full of vendors and buyers. I told him what I saw. Then he held up a mirror and instructed me to look into it. He said, now what do you see? And I said, I see my own reflection. I told him, I'm feeling a bit silly. He said, see, that's what happens when you let silver get between you and the market. Interesting little story about some old man somewhere I found, I couldn't remember. But I want to tell you this. I think it's important in developing a practice to develop a relationship with clients, client referral sources, and people that you know. My friend Terry Giles, whose name is on the front of this courtroom, was my debate partner in college. And he got out early and went to Pepperdine when it was a little office building in Santa Ana. And got his practice going. And he brought me into work with him. When I was a law clerk, I got to sit through about 8 or 10 trials at the council table. It was an unbelievable education to do that. And he told me, the way you build up a practice is pretty simple. You get 10 cards a day and give it out to somebody. And he would give them out to the dry cleaner, ice cream man, whoever. And he said, over time, there's just a torrent of business that comes in. And I said, well, how do you do that? And he said, well, you ask for their card. I said, what are you talking about? I said, well, you don't just walk up and say, here's my card, I'm a lawyer. You say, oh, you're in the dry cleaning business, can I have you have a business card or something? And while he's giving you his business card, you give him yours. And he said he did that 10 times a day for a year. So that's a lot of cards out there. And Terry had more business than he knew what to do with. And we were very fortunate. I got out of law school and made a deal with him. I said, look, I know you guys don't have a lot of money. It was in the 70s, early 70s, late 70s rather. And I said, so you guys can't pay me a big salary, but how about lease me a car and give me 50% of what I bring in? I thought that would be a fair deal for all of us. I could have a car so I look like I'm a lawyer because I had a beat up car that I was driving. An old used Cadillac. It was a cool car, but it was old and used and crappy. And so he got me a car. And I went to all the bars and liquor stores that had some contact with my family. My father and my grandfather had saloons, one in Sunset Beach called Captain Jack's. If you've ever been to Sunset Beach, you know what it is. You know that because you're working around there. And my grandfather's bar was on Main Street in Huntington Beach for years, since Prohibition until the early 60s when he sold it. And everybody would work all week until 5 o'clock, then go to the bar and drink till 9, and then go home and come back the next day and do the same thing. And you could name the people on the chairs by where they sat. And he used to run buses up to the ball games and had all kinds of activities with the Rotary Club, and my grandfather was just there. My grandfather's brother, Uncle John, who I was named after, my dad called him our drunkle because Uncle John hit the sauce. There's a rule in the bar business. You can't drink behind the bar if you're working behind the bar. So there's big mirrors behind the bar, and there's a little door right over here with a little kitchen. Uncle John would stand inside the door and drink his straight vodka with water back. And everybody knew he was standing there drinking, and he would drink all day long. He was quite a guy. He also taught Canadians how to fly out of Meadowlark Airport down there. And then some Canadians went over and fought in World War II. Well, the family business was very good because about 2 months into this, Terry came to me and said, partners won't let me give you the money. And I said, you give me what money? The money that I bring in? And he said, yeah, they think it's not fair because they're not getting as much as you are. And I said, well, I'm just bringing in it was mostly DUIs or people who had fights or whatever in the bars and all that. So I said, okay, so I went out to my own office with 2 DAs, 2 really good DAs. One guy was a really good frontline misdemeanor DA. The other guy was a big time special assignments extradition guy. And we went out together and had a hell of a business. Did very well. Everybody had referrals. And that was pretty much how we got our business, was referrals. We didn't think about it too carefully. We just went out and told all of our friends and sent out announcements and did all that kind of stuff. Dolan, Bailey, and Riedepel. Julian Bailey just retired from the bench in Orange County because he was investigated by the bar for his behavior. He was a good guy, but he was just a little bit of a wild man. And made a few comments to a few public defenders that was slightly offensive or off color. And did a couple other things, and he just decided he'd retire. And I thought, well, that's Julian. I got to go see him next year when I go down on the beach. And hell of a lawyer, though. And 2 sons played water polo for UCLA, All-Americans. Beautiful daughter lives down in San Clemente. And Jerry Riedepel was a ladies' man and hell of a racquetball player. Great athlete. He's a pickleball now. He came and told me 3 years ago about pickleball. I said, what the hell are you talking about? When I look at that game, I wonder what they're doing. Anyway, I want you to know that we developed our practice to where we were really doing very well. And I went back and looked at what we were doing. I wanted to see if I could pass along. I know some of you don't really care about that. You've already had your practice and you're retired. But I was thinking of Pete. Because Pete's got a task to build up a little practice out there in in Nevada based on the practice out here.
Okay.
And this book sort of came out of that 15 years ago. I said, let's see if we can figure out a way to advise lawyers on how they can build their practice. Of course you'll make money, you'll get paid, but that's not the interesting or the first objective. So this first formula I want to tell you about is the one we put in the book. Some of you like formulas, some of you don't, but let me tell you, this is the easy way to communicate it. TA equals CR, and it shouldn't be equals, it should be dash. I gave this to Irene printed out. TA plus CR plus PA times AD equals success. TA is technical ability. You have to know what you're doing first. You cannot practice law and not know what you're doing. So that's just important. Some people think that's all you need to know. And those people are working for other people and getting paid to do what they know how to do. But you got to know what the business is. You got to know what criminal law is. You got to know what family law is. You got to know how the business or the profession works. CRS is client relation skills. How do you get along with people? How do you keep in touch with people? How do you keep people informed? PA is profession or persuasive ability. You got to be able to persuade people, especially when they're coming at, decide if they want to hire you as a lawyer. Times achievement drive. You got to really want to do this business in order to be in this business. You got to really love the profession. That equals success. Now, that formula is what's in the Rainmaker, and there's a long story behind it. The guy that is teaching a young man, a new lawyer, how to develop his practice. And I bring it to your attention now, but I want you to read the book. Just set it by the bed or set it by your chair or whatever. You don't have to make a big deal out of it. Just read it. It's a nice little story. We are told that people learn things in story form, and that's why this is in story form. The second point that comes out of this book that I think is terribly important is the 80-20 rule. Most of you have heard of the Pareto principle. 20% of your clients give you 80% of your income. 20% of your clients give you 80% of your aggravation. There's just that ratio. Well, it says 16 times M3. 16 is how many touches a year you want to have with people. That's once a month and maybe 4 other times. That means you send somebody an email, an article, a comment, the people that are referral sources that you want to develop as referral sources or clients. 16 times a year you have some contact with them. Their birthday, their anniversary, whatever. You remember those things about people. And then you have M3 is really a mastermind group. Should be M2. You all know what a mastermind group is? Does anybody know what it is? It's interesting because in the speaking business where I was for about 25 years while I was practicing, it's very common. You get together with people that are in your profession and you get together and talk about best practices and what's going on and what can be done to be better at what you do. And those meetings turn out to be very valuable. We're trying to set that up with our third-year law students now that can become certified law clerks. We're calling a conclave on Saturdays where they come together. They're certified law clerks for various people. Have them come in together and talk about what they're doing. It also helps us to support our legal clinic. And it's just a great idea. If you've never been in a mastermind group, you got to think about that. Think about 3 or 4 people that you really find inspiring or really smart or really gifted in what they do. And you get together. You don't even have to have an agenda. You just get together once a week, once a month, whatever you set up. Mastermind groups are powerful. And I've seen many people get assistance from a mastermind group that makes a massive difference in their productivity and in their success. So it's 80-20 is a ratio of dollars to clients, touches are the 16, and M is the mastermind group. And if anybody wants to talk about this sometime down the road, just give me a call and I'll talk to you about it. I have a friend up in Lake Tahoe now who's always reaching out to start new groups, because you can sometimes become a member of more than one group. And he is just such an advocate. He reminds me, he inspires me. Now, the last one is about media. When I got out here, I didn't have any business. I didn't even know why I was here. I found a house development, and Irene and I were out here booking an MCLE program, and I said, God, that's a great looking place. Let's go over and look at it. We looked at it and said, yeah. And they said, well, we don't have any available, but we'll open up a new division or segment soon. So we were out here again, and they called and said, all right, come down and make a deposit. And I didn't know what they were talking about, for this house that is not even built yet. So we had to scrape up $5,000, which at the time seemed like a lot of money, and it was. And we went over there, made the deposit, and they said, okay, you can choose from these various lots. We chose the biggest lot, 15,000 square foot lot. And they said, okay, we're gonna start building, you'll come back in about 9 months or a year. So we come out here every 2-3 weeks and watch what they were doing, clearing the land and putting the foundations in and building whatever they had, metal studs and all kinds of interesting stuff. And New Year's Eve of 2004, we slept on the floor, we mentioned that before, and we moved in. I loved the place, and it's just the best. But I got out here, Jim Silver rented me some space. I tried about 10 times to get a hold of him because he had a sign on his door, but I couldn't find it, got a hold of him. It's right across from the courthouse. And I made a deal with him to get some space in that building. Hilda Zamora's in there now. None of you would probably know Hilda other than local lawyers. She's a very nice person, very entrepreneurial young female lawyer. Well, so I said, what can I do? I mean, I have a criminal law specialist designation. I took that exam before we moved out here. And I laughed. I said, well, what if I don't pass it? I'm not telling anybody if I don't pass it. But I passed it. So I'm a certified criminal law specialist. So I called Barbara Brand and I said, Barbara, she was the one who ran the conflict. And I said, I'm a certified criminal law specialist and I know guys that you have out here. Could you put me on that conflict panel? And she said, no, not right now. And I said, oh, okay. So I was messing around, trying to figure out what I was going to do next. She came to me when they had an 8 co-defendant murder case because she didn't have enough lawyers to do it. That's why I was on there. But radio and TV, it always interested me. I had gone to a school in Los Angeles for radio broadcasting, and I love TV as a TV junkie. How do we do this? So I'll tell you, if anybody's still interested, I know some of you don't care anymore, you just want to go home and watch the game. How do you get on television or on the radio? It's a really simple process if you understand it. Radio and television have news directors, people who put together the news show every day. And you find out who the news directors are, and then you look at the newspaper, you don't get newspapers anymore, who gets it? You look at the television, you listen to radio, you find out what's in the news. That Mangione guy up in New York is getting tried. The guy that killed Charlie Bird, I forget his name now, up in Utah. ICE, remember the 5-year-old kid with ICE? It's been all over the TV. And the protesters in the church back there. What you do is you take one of those kinds of subjects, come up with 3 bullet points, and you email it to the news director. And you say, if called upon, I can make comment on this. You might come up with some clever, insightful thing about those events and get it to the news director. And the news director will eventually call you and say, can we send somebody out or you want to come in the studio? If you know what you're talking about. You've got to have it in your area of expertise of the law. That's the idea. So you're looking for things in your area of expertise. You're looking at oil and gas would be great. I mean, you could be a fantastic guest on media shows. I got to the point where I was showing up on Fox News Channel all the time because I got the news director's address and I kept sending them stuff and they kept calling. And we could do a remote from out here, which is pretty cool. And the local TV I got onto for about 10 years, once a week to talk about whatever's in the news. Just tell me the case in the news, I'll tell you some things about it. And then we got a radio show. My comedian friend from Chicago and myself had a radio show here for 8 years. And it was just silliness, but we had a good time. And we got good advertising value because of it.
I tuned in, listened to you many times.
Ah! Yeah, no, we were just stupid. So radio and TV helped. Print media, I didn't have much to do with. I do have somebody who does a press release if we have anything to release about. Yeah, but those are the three areas of media, radio and TV by far the most important. TV the most out of that. So if you ever are interested in doing television to develop a practice or simply just share your knowledge, that's all you gotta do. Find who the news director is, give them 3 points on whatever subject comes up. First few times they won't talk to you. Eventually, especially if you have something to say. You know, all these weird cases that come up, there's some things, some insights that you can talk about that most people don't have. I was working with F. Lee Bailey early in my career, and I was in Boston with him, and he'd just been on television, and he was talking about how bad the case was and how the guy should be prosecuted. And I said, why are you doing that? And he said, well, that's what they want to hear. And I said, well, aren't you the defense lawyer? And he said, yeah. So from then on, he kept telling the defense side. I said, well, look what I did. I influenced him. Maybe not. Maybe he didn't give a hell about what I said. But like this Mangione guy, you gotta wonder what's going on with him. Remember, he was busted in the McDonald's. So there's some things you could say about that case. Like, you always start out with mental issues, mental health. And then you'd see they're already raising issues about search warrant in his bag where he had stuff. And you just make sure that you can make a comment that's relevant about what's going on with that case. If you had that case, what would you do? What if you had that case, Bert, that killed Bert? What's the guy's name, Cook or something up in Utah? That would be a tough case to have. I don't know what I'd say about that case, to be honest with you. This ICE, though, with the 5-year-old kid, I heard the explanation that the father ran out of the car and left the kid. And the ICE people took the kid over to the house, and nobody would open the door to pick the kid. So they took the kid and gave him something to eat at McDonald's. Excuse me for mentioning McDonald's so much.
Took him to Texas.
And got him back to the parents eventually, I guess.
5-year-old kid's in Texas.
Huh?
They took the 5-year-old kid to Texas. That's
Texas?
Right. Yeah.
No, I think that was that in Minnesota? Am I wrong? Wherever it was getting cold outside, I know that. And they took the kid and helped him out because otherwise he'd been left in the car and froze to death. The protest in the church is one that I think would be very interesting. Because people are talking about the First Amendment right to protest, which they have. The First Amendment also includes the freedom of religion. And there's some case law and some statutes on that subject. And it seems a little weird that people would go into a church meeting and start protesting, but they didn't like the guy who was the reverend or whatever, or he had some relationship to the bad guys, I guess. And that's a story that will live for a while because, strange as it seems, first thing would say, First Amendment right, yes, for protest. First Amendment is also there for religion. You can't trample on somebody's religious rights. And then the question is, did these people commit a crime? I guess there's some statutes I don't know about. I started hearing about them, and I want to know about that. These are things, every day in the news, there's something about everybody's specialty, if you look for it. You got to look for it. But there's something about insurance. There's something about fires. There's something about gas, oil and gas. There's something about crime, of course, every day. There's all kinds of things that are in the news. Well, news directors have a problem because they have to put on a news show. And so they have to have subject matter. And they don't want the same old stuff. So when you give them something to talk about on one of the interest-worthy subject matter, they are interested usually. Those are the people that make up what goes on the news director. The guy down in KMIR, he's David Reese, he went down to KTLA in LA and he came back now. I haven't been able to get back in with him. But Karen Devine's a friend of mine at that KSQ. And we're trying to make a bidding war between those two to see if I can get back on my weekly thing. I saw Fred Rogan is on KMIR now. He's out from LA. Interesting guy. Here's a guy named Wise comments about the Goose case, by the way. So, those are the three things I wanted you to get. For Pete, especially because Pete and I talked a lot, and we'll see each other again Tuesday. I want to work with Pete on this, and I want to especially work with Pete on getting some media coverage because he could do stuff. He was a prosecutor of the year in California.
Okay.
Ben is a heavyweight. And he has perspective that other people don't have. And I think if he started working up, I know Pete can work up 3 bullet points because he makes believable handouts, incredible handouts for our classes. And 3 bullet points on weird cases, and Pete would be on the television. And he knows how to project it. He goes on Zoom usually, so he knows how to work the Zoom, and that could be right from Henderson, Nevada. You could be on KNR, KSQ. And he's got the credentials to do it. Hey, so that's what I hope you get out of this book. But read this book just for the story, because the story, I think, if I do say so myself, is interesting and gives you some information that you can use if you're interested. For those of you that are retired, just look at it as a review of your history and see where you were. Anybody have anything to say about how they developed their practice?
Hey, John, I want to ask you a
Go ahead,
question
go ahead.
after, because I don't want to hold everybody up, but
Okay,
with respect to some of the marketing that I do,
Okay.
a lot of what you're saying is resonating. but I
good,
wanna
good.
Compare notes.
All right, well, I'm gonna let you hear about technology, because Rusty Velasquez, this guy was a DA in Los Angeles County, came out here by storm, and is one of the best guys, one of the best